Thank you very much for the opportunity. I'm going to tell you a story of Indonesia, where I believe that the state is in retreat, but not so many people are realizing that our state is actually in retreat. And there are consequences for that retreat on administrative law protection. Now, you're probably aware that administrative law protection in general is that if you build a house and then you don't get a license, you can go to the administrative court and say you complain for that, not giving them a license. Or another example is there is protection under public service law. For example, if the bureaucracies are not so good, you want to complain, and then there are sanctions here under Indonesian public service law for public officials, such as removal from office, demotion, suspension of salary raise, termination, or even revocation of license. And then we know that there is also the freedom of information law. It's quite common in several other countries, also in Indonesia, which obligates documents to be disclosed. And then there are some access to participation in decision-making process, and then there are redress mechanism and guarantee of service quality and quantity. Now, these are the traditional administrative law protection granted in various jurisdictions, I suppose, including Indonesia. But what happened then if the state is in retreat and then delegate the services to the private sector, or as I say, to non-state actors? So, in theory, it should be like this. Now, you see here in the left-hand side is the old positive state before privatization, contracting out, and etc. So we can have a direct claim there. So the licensing, the armed forces, of course, it's not usually privatized. The judiciary is not privatized. Civil registration is not privatized, mostly, but some can see there are examples where they are privatized. And then the water, electricity transfer is still not privatized. And then the old state is now reconfiguring into the so-called regulatory state, in which these several services, such as water, electricity, or transport, is now being delivered by non-state institutions. And now the function of the state is not in delivering the services directly to the people, but simply in regulating them. And in this regulation, there are some publicness. I'm not saying that it's a perfect sort of publicness, but there are some guarantee of redress mechanism, transparency, access to justice, participation, and so on and so forth. So in England, for example, after Thatcher privatized in 1997, Ofwat as a regulator was constituted, and then in 2003, the Labour came ascended to the politics, and then there is a prohibition on disconnection for non-payment. So this is actually the result of the Labour who is taking over the politics at the parliaments at that time. So there is some guarantee of publicness, and because the regulatory state is functioning. But what happened in Indonesia is this. So we have this privatization, contracting, and outsourcing, but the regulatory state does not materialize. So there is no regulatory state. So there is no regulation of the privatization. You can imagine now that the government is handing over the water utilities to the private sector without accompanying them with regulation at all. So they just sign a contract and that's it. So in terms of the law, you don't have direct access to the company. So you can see here that the public is in relationship with the water utility only privately as a matter of contract. So you cannot say, I have a right to water, why don't you give me my water? I'm not being disconnected. No, you cannot say that. So it's just a matter of private contract. There is no public law protection whatsoever. And we have several case studies that I've written. So one example is in the region of Batam, which is quite near to Singapore, 30 minutes by ferry. We have a 25-year concession contract awarded by the authority. Of course, then there is this obligation to supply, finance, and everything. And then what happened is in 2008, around 4,500 houses, which have already been occupied, so there are people living in there, they failed to be connected to the network. Now, the private sector claims that they don't have the money for it under the concession. And then they go to the Competition Commission, which is rather weird. I mean, why is it that you don't have water and you have to go to the Competition Commission? absolutely weird. So the Competition Commission decides, and they actually won the case. I mean, the citizen won the case, and they decide that the water utility is discriminating business entities. But this is rather problematic, because if you're claiming for water, it's not like you're buying a laptop or something like that. So, but are citizens in need of water as business entities? Okay. And then they have another decision there, abusing its dominant position. It's a common competition law case. But this is also problematic because determining the condition of trading with the intention of preventing consumers, also limiting markets and technology development. These are the two conditions for abuse, and actually none of these are relevant for water consumer. So we don't have a standalone regulation, water regulation following privatization, then we have to complain under the competition regime. And then again here it says, the water utilities are controlling the production and marketing of goods which result in monopolistic practices. This is also problematic because water services are by characteristic natural monopolies. So they are already a monopolist. And why the court are actually punishing them for being a monopolist? The court are actually doing that because it cannot find any other legal avenues to punish the water utilities, because there are no regulations, as I stated before. So they have to take the Competition Commission and rather bend the law a little bit to allow them to have connection, water connection. So the important lesson here is that the contract was between Batam authority and the private sector. Citizens are not a direct party to the contract. They do not have legal standing. So if we have a state-owned enterprise, I'm not advocate of state-owned enterprise, but if we have a state-owned enterprise and then we have, they're disconnecting us, we may have legal standing before the court because the public thing is a public law and the public administration. But since this was privatized, then we are not a party to the contract. So, and then they need to be described as business entities in order to claim the right to water, in order to claim the Competition Commission. That is really absurd. We can see again here, although the claim is successful, water is regarded as a pure commodity, so it is adjudicated as a competition, not as a human right or as a public law matters, so as a pure commodity, and to be argued in accordance with competition principles. If the services remains to be delivered by Batam authorities, they may have been liable under general administrative law, and citizen will have a direct claim. So under the status quo or the positive state, the citizen may have a claim, but this is not the case. And now let's talk about also another case of the public service law. So after 32 years under Suharto regime, we have the public service law. And then the law here doesn't say anything about privatization, but it says an undertaker of public service function may conclude cooperation in the form of delegation of parts and blah, blah, blah. So this is exactly what we call it a disguised privatization. Because if the law says privatization, the court are going to strike them immediately. So the government strategized against that, and they are inserting fake clauses such as this through contracting or cooperation. So the language is like that. So they can actually privatize, but through contracting, not full divestiture. But this is a disguised privatization. So, for example, in public service law, we talk about removal from office, demotion, suspension from salary, termination whatsoever. But since this is privatized, they are regulated under ordinary labor law. So just like a corporation employee, and the government cannot say anything. If you don't get this connection from water, for example, the government cannot fire them. Whereas if it's delivered by the government, of course the government can fire or suspend, but since this is delegated to non-state actor, then the government can't do anything about it anymore. So this is the state in retreat. Another example is the freedom of information law. Now, the freedom of information law is applicable, of course, to the city government and to the state-owned water utility there. But it is not applicable to the concessionaire there. The Palija is under as a subsidiary, and also to AETRA, and also not applicable to the regulatory body, which is rather absurd because the regulatory body in England, which is, it's very neoliberal state, the FOI law is applicable to them. But since the Jakarta regulation is set up under a contract, so this is called regulation by contract, the regulatory body, the FOI law is not applicable to the regulatory body. So we cannot ask them to disclose information on tariffs and everything and on the decision-making process. So why is that so? I'm offering two explanations here. The first is there is a rejection of the regulatory state by judiciaries amidst disguised privatization by the executive. So our constitutional court is very, very strong. If there is something about privatization on the law, they're going to strike down the law immediately. The government is quite neoliberal, so then they do this disguised privatization. And this tension is actually avoiding regulation from taking place. If, for example, we don't have that tension, then we have the regulation, and the regulation would enable the private sector to be regulated and subjected to some transparency principles. But this is not the case. And then secondly here, there is a move of good governance by the civil society, right? Through the FOI law, freedom of information law, and the public service law. But these good governance reforms do not directly attack the private sector, do not directly refer to the deliveries of services by the private sector. So they are actually looking only at the state, whereas the state is now actually hollowing. So there is no use for doing FOI. Well, of course there is some use. The bureaucracy could become more accountable, the licensing could become more transparent. But what if the licensing is now privatized? What if water utilities and privatized, there is nothing else regulating them? So I think this is the final slide. I hope I'm not speaking too fast. Thank you very much.